by registered post with AD as well as by usual mode within 7 days from the date of this, returnable on.
My Lord, time for the respondent number 1. I may be given 3 weeks time for filing my affidavit. Make motion, let me. Oh, sorry, I'm sorry.
My Lord, may please your Lordship, 22/2/2024. And after that, and after 7 days, the assessment of crops was. That means, my Lord, our grievance is that our new house passes were already issued before the assessment was done, and the spot verification. But the respondent did not give us any land value. They give us only a crop value.
Give you what?
At the time of the spot verification and the assessment was done, our new house passes were already in our hands, were already issued.
We issue notice. Who is appearing for? Ms. Vanessa Sami.
Respondent number 4.
Appearing for respondent number 4.
I'm for respondent number 1.
As well as Ms. Zairem Sangpui, Learned Central Government Council, appearing for respondent number 1. And Mr. Samuel Vanlal Shiata Changte, Learned Additional AG, Standing Council for NHIDCL, Learned Standing Council for NHIDCL, that is respondent number 2 and 3. This writ petition has been all of you,
Yes, my Lord.
the respondents have them. However, they shall be served with, you have been served with the copies of writ petitions. Okay. File their affidavit in oppositions. The prayer is allowed. Let this matter be listed after 4 weeks. Yes.
May it please your Lordship?
Yes.
May it please your Lordship? Yes, our case is that we have been issued impugned letter. Yes, our case is that we have been issued impugned letter, my Lord. AIFFD licensed instructor and Asian Football Confederation C licensed instructor. Number 2 to 6, dated 11/2024. Petition is at 10 and 11, starting from
Page number?
70, my Lord.
70.
Yes, my Lord, 70. Annexion number 9.
What is this?
Yes, if I may read, my Lord.
No.
Yes, to Daniel Duoma, this is the petitioner number 1. Subject violation of Article 62.3 of the AIFF Disciplinary Code 2006, also called the Code. The letter will confer regulations or obtain any other improper advantage, regulations or obtain any other improper advantage, regardless of whether that advantage is penalty, fine of at least rupees 3 lakhs and a ban on
No, what was the allegation against you? What you did?
My Lord, we have been charged with an offense of doing some business with some third party for match fixing and match manipulation.
Fixing.
Yes, my Lord. However, regarding the allegations, we have no involvement in the said activity, my Lord. If I may kindly have your Lordship's attention to the annexure 1/6, my Lord. Page number 56. 6, my Lord. Page number 56.
Yes.
Second
Yes.
paragraph.
Yes.
Flavius Lalrodkima, 23, son of Dennis Roming Thangabayrabi Forest Bank Colosive District, phone number so and so of Ramlun Athletic FC, When he is called in for questioning, he said that he had nothing to say regarding the business. That and the findings of the investigating officer against the petitioner, my lord. Yes.
What?
Yes.
What? The accusation was that
Petitioner number 2 was the only one who was summoned to the police station, my lord. The rest of the petition
inquiry conducted
disciplinary
by
committee-
police or
disciplinary committee, my lord.
by police or by the
The disciplinary,
Federation-
the disciplinary
Federation.
committee, my lord. The,
okay.
yes, this inquiry report was submitted on 28 October 2024, and disciplinary was called thereafter on 2024, and disciplinary was called thereafter on 31st October 2024, which basically means that this disciplinary committee was conducted upon the, as per the inquiry report, my lord.
Okay, we'll issue notice.
My lord.
Heard Miss.
My lord.
Heard Miss. What is the name?
Valentina. Yes, 7 and 8, my lord.
No, authorities.
No, my lord.
Authorities.
No, my lord.
They are registered under the Firms and Societies Registration Act, moreover, my lord. And also there's a judgment, landmark judgment, wherein 5 judges bench decided that the BCCI was also a state and was also part of a state under Article 12, which can be read as the other under Article 12. Similarly, my lord, the MFA has deals with the activity of food within the state of having the highest authority. Hence, they can be called as the
No,
other
it may
authority.
be that this writ petition is maintainable,
My lord,
and the relief you are the respondents, and you are aggrieved by action of question of maintainability open. You can raise this question
Yes, Your Lordship.
before we move. We are issuing notice. Led Government Council has raised the question of maintainability, Article 12 of the Constitution of India. Article 12 of the Constitution of India. The question regarding the maintainability shall remain open.
Admission item 5.
Rental compensation.
Okay.
Rental compensation.
Okay. You have anything to say? No issue. Heard Mr. Vanlal appearing for respondent number 1.
Service of notice by way of Dusty, respect of respondent number 4. Also file an affidavit by way of Dusty, respect of respondent number 4. Also file an affidavit of Dusty.
Yes.
My lord, I'm here on behalf of Miss Mary L. Kyangte, and she will be representing respondent number 4.
Oh, you will be appearing for respondent number 4.
Yes, my lord.
Okay.
And power will be
Appearing for respondent number 4.
yes, my lord.
Okay.
And power will be filed within the course of the day.
Who is appearing for petitioner? Also Miss Dusty Mon. Stop. On the other hand, Miss Deborah, Learned Counsel submits that Miss Mary L. Kyangte will be appearing for respondent number 4 and will be filing her wakalatnama
Within the course of the day, my lord.
within the course of the day. Stop. It also appears that the notice is issued to respond.
My lord,
Yes.
this is application for condonation of 548 day delays.
How
for
many
filing
days?
RFA.
500 and
574 days. My lord, there is no any negligence on the part of the applicant for filing the RFA, my lord. There, for government, there is some other formalities to be done prior to filing. In civil suit number 3 of 1997, order person. 3 of 1997, order person. In that make a submission relating to the facts of the case. The union of time we have lease agreement between the original owner. Then we have yes, that is by law. I mean, we are not liable to make a payment of rent later on, my lord. And order, my lord. And order, my lord. We are
you contested the suit. You were
petition from Para petition from Para to followed by the applicant headquarter 24 BRTF that just Para 8. Then at Para 9 on August 1st, 2023, duly recommended by Chief Engineer, was forwarded to Assistant Legal Advisor, Branch Secretary. Is also enclosed at Para 21 that on is also enclosed at Para 21 that on 6 October 2023, for 6 October 2023, further on the subject case along Director General Board Roads is also enclosed at Para 25 on 20 also enclosed at Para 25 on 20 November 2020, headquarter 24 but 274 RCC, White letter number 2023 number 231 on 19 January 2000 by duly recommended by Chief Engineer along with all relevant documents. That letter also enclosed at Para 33 that on 10 February 2024 in turn 2024 fresh specific recommend the headquarter additional directorate general board road. That letter also general board road. That letter also enclosed at Para 37 on that the instruction has been issued to the 24 BRTF for forwarding draft appeal prepared by CGC along with all connected documents via headquarter Chief Engineer Project Puspak letter. That letter headquarter Chief Engineer Project Puspak letter. That letter also enclosed 24. Issued to CGC for submitting draft appeal. White letter issued to CGC for submitting draft appeal. White letter dated 29 May 2000. White letter dated 29 May 2024. 44. Government Council was requested to prepare draft appeal white letter dated 3 April 2000. Document which was handed over to her was not incomplete. Was incomplete to prepare draft appeal. So the learned Central Government Council took 84 days for collecting document as well as same. However, since the required document mentioned by the CGC could not trace from their end, she herself trying to collect the same from the concerned court. 46. That on 11 October 2024, draft RFA along with its IA has been received by headquarters CE project from 24B duly vetted by Ministry of Law and Justice of Legal Affairs Branch Secretariat Kolkata has been received. White letter so and so dated 5 November 2024. Draft RFA duly recommended has been forwarded Headquarter Director General Border Road by Headquarter Additional Directorate General Border Road is for approval of competent authority, white letter so and so dated 16 December 2024. 55 on 13 January 2025. 55 on 13 January 2025, draft on 20 January 2025. The case has been request of RFA for filing before Honorable Court through Central Government Council, white letter so and so dated 1st February 2025. That on 26 February 2025, the RFA along with the requisite copies has proceeding, and there was no negligence on their part for filing the proceeding, and there was no negligence on their part for filing the same. The appellant therefore submits that its fifth case where this honorable court may please to condone the delay in filing the instant appeal. My lord, that as per my petition, my lord, we explain the gap to gap of delay. Then I have two citations, my lord.
Yes, give me. What is it? What is it?
Page 136.
Yes.
Fourth line. The facts that it was state which was seeking condonation and not private party was altogether 11. The doctrine of equality before law demands that all litigants, including the state as a litigants, are accorded the same treatment, and the law is administered in the even-handed matter. There is no warrant according to stepmotherly treatment when the state is the applicant. That is another point. Then, my lord, and lastly, in this citation, at page, then no separate standard to determine the cause. 7 SCC 121.
Paragraph number.
1998.
What is the para number?
Para 9 to 12.
What is the
My lord, if I may permit it, of this court, my lord.
yes? It also says is property sufficient.
Yes.
Yes, for seeking
Time.
no time.
No.
Seeking approval of the authorities.
No.
Seeking approval of the authorities whether to file an appeal or not.
Yes.
There was
There is
then
no-
after a decision is taken, then for waiting again. Now, while doing everything, you have to be aware that the limitation prescribed by the statute is only 90 days.
My lord, however, it was beyond our control because we have to move table to table.
No, you have not paid any heed to the statutory provisions.
No, my lord. We are trying to, my lord, we are trying to file appeal as soon as possible, my lord. However, due to some other formalities that should be required as per the governmental proceeding, my lord, we are late.
Now, answer my query. Statute prescribes a limitation period of 90 days.
Yes, my lord.
Whether governmental proceedings for taking a decisions, the internal has to be 10 times of that statutory periods, or it has to be within that 90 days. The government must be aware that any decision which has to be taken within 90 days. And then if some unavoidable delay is caused, that may help. Then, but here, in mere internal correspondence, you took time for more than 1 year. So can it be regarded as unavoidable?
My lord, 90 days is not enough for.
But that is the
Internal
prescription of the statute. Then you have to move the. I am not taking decision, I am putting queries.
Yes, my lord.
Okay, yes, Mr. Malhotra.
Your Worship, before I come to the merits of the submissions made by my learned friend, Your Worship, I have taken a preliminary objection to the Government of the Surface Transport / Ministry of Defence. Number 2 is Chief Engineer, BRTF Project Pushpa. Number 3 is Commander 24 Border Roads Task Force. Sorry, number 3. Number 4 is Officer Commanding Unit 107 RCC BRTF. Number 5 is the Secretary Border Road Development Board, Sena Bhavan, New Delhi, and number 6 is the Director General Border Roads Organization. So these are the 6 applicants who have filed the condonation of delay application. At page 3, the affidavit accompanying this application has been sworn by one Mr. Vikash Kumar Singh, who is the Officer Commanding 74 RCC. But he is not one of the applicants. He claims that he has been authorized by the applicants who want to file the instigation, but no document has been executed. Applicants number 1 to 6 authorized an interlocutory application. And CPC is very clear, Order 27, Rule 1.
What it provides? Order 20, CPC.
Order 27, Rule 1, suits government.
Yes.
Order 27, Rule 1, suits by or against government. In any suit by or against the government, the plain or written statement shall be signed, government may, by general or special order, appoint in this behalf, and shall be verified by any person whom the government may so appoint, and who is acquainted with the facts of the case. 27, Rule 2, persons authorized to act for government. Persons being ex officio or otherwise authorized to act for government in respect of any judicial proceeding shall be deemed to be recognized agents by whom appearances, acts and applications under this code may be made or done on behalf of the government. So that is the law. And if I may take your lordship to 2007 3 GLT, page 113.
Para?
Para 12. Para 12, Your Worship.
Yes.
The Apex Court in Observator of Forest Supra has observed provision contained in Section 79 CPC as well as Order 27 Rule 1 CPC is not merely a procedure formality, but is essentially a matter of substance and of considerable significance, whereby the special provision as to how the central government or the state government may sue or be sued has been indicated. So it is not only a procedural formality, but is essentially a matter of substance and considerable significance, whereby special provision as to how central government, the affidavit, 74 RC, para 1 he says, I was 74 RC, para 1 he says, I was authorized by the present applicants of this application.
Just a minute. Yes, what is this?
This is a letter order dated 21/4/2023, passed by so and so. So this is the letter CGC to legal opinion. 64. What I'm trying to say is that from 24th of May 2023, what I'm trying to say is that from 24th of May 2023 till 20th of September, the applicants were seeking the opinion of the Ministry of Law. Copy of Ministry of Law and Judicial Ministry of Law. Copy of Ministry of Law and Judicial Department, Department of Legal. Copy of Ministry of Law and Judicial Department, Department of Legal Affairs, Judicial Department, Department of Legal Affairs, branch sector called advice on dated 20th September 23 is forwarded with for information and necessary action, please. It is requested to forward the specific recommendation of Commander Task Force, that is, whether to implement the judgment pronounced by the Honorable Court of Senior Civil Judge based on legal opinion of CGC and AL, that this is the Department of Legal Affairs, or otherwise, along with so again, in spite otherwise, along with so again, in spite of the opinion of the Ministry of Law, I'm sorry, I'll just take your lordship to the relevant page. The Ministry of Law was again obtained, Your Worship. That is at page 101. But before that, Your Worship, so as Your Lordship will see, the Ministry of Law on 20th of September 2023 opined that there is no ground to appeal. In spite of that, the applicants kept on writing to each other whether to implement or and at page 85, Your Lordship, page 85, annexure 31, till 26 March 2024, the implement the decision of the trial court as per the decision of the Ministry of Law and the CGC. And then on 26th of March 2024, competent authority gave approval to file appeal. And in spite of this, the appeal was filed on 13th of February. And in spite of this, the appeal was filed on 13th of February 25. So it took them nearly 1 year to file the appeal after the competent authority had given approval by this annexure 31, letter dated 26 March 2024. What does this point out? This surely points to the casual attitude, absolute negligence of the applicants in pursuing the matter. competent authority has already given them to file the appeal on 26th of March 2024. And they are filing the appeal on 13th of February 2025, nearly 1 year later. So, my learned friend has said that, yes, it's because of pushing the file from one desk to the other. Supreme Court has held on many times that that cannot be a good reason for condoning delay. In that regard, Your Worship, I'll take Your Lordship to 2020-10 SCC. 2020-10. I'll read from para 3 onwards, Your Worship. It's a very short judgment.
Yes.
No doubt some leeway is given for government inefficiencies, but the sad part is that the authorities keep on relying on judicial pronouncements for a period of time when technology had not advanced and a greater leeway was given to the government. This position is more than elucidated by the judgment of this in Postmaster General versus Living Media (India Limited), wherein the court observed as under. I'll read this. It is not in dispute that the persons concerned were well aware or conversant with the issues involved, including the prescribed period of limitation for taking up the matter by way of filing a special leave petition this court. They cannot claim that they have a limitation when the department was possessed with competent persons familiar with court proceedings. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically merely because the government or a wing of the government is a party before us. Though we are conscious of the fact that in a matter of condonation of delay, when there was no inaction or lack of bona fides, a liberal concession has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the department cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and inherited bureaucratic methodology of making several view of modern technology being used and available. The law of limitation undoubtedly binds everyone, including the government. In our view, it is right time to inform all government bodies, their agencies and instruments have reasonable and acceptable explanation for the delay, and there was bona fide effort. There is no need to accept the usual explanation that the file was kept pending for several months, years due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be swirled for the benefits of a few. Considering the fact that there was no proper explanation offered by the department for the delay except mentioning of various dates, according to us, the department has miserably failed to give any acceptable and cogent reasons sufficient to condone such a delay. 8 years hence, this judgment is still unheeded. Para 4, a reading of the aforesaid shows that the reason for such an inordinate delay is slated to be only due to unavailability of documents and process works. It is inadvertent that delay occurs. It is inadvertent that delay occurs. Para 5. A preposterous proposition is sought to be propounded that if there is some merit in the case, the period of delay is to be given a go by. If a case is good on merits, it will succeed in any case. It is really a bar of limitation which can even shut out good cases. This does not, of course, take away the jurisdiction of the court in an appropriate case to condone the delay. We are also of the view that the aforesaid approach is being adopted in what we have categorized earlier as certificate cases. Object appears to be obtain a certificate of dismissal from the Supreme Court to put a quietus to the issue and thus saying that nothing could be done because the highest court has dismissed the appeal. It is to complete this formality and save the skin of officers who may be at default that such a process is followed. We have on earlier occasions also strongly deprecated such a practice and process. There seems to be no improvement. Purpose of coming to this court is not to obtain such certificates, and if the government suffers losses, it is time when the officer concerned responsible for same bears the consequences. The irony is that in none of the cases any action is taken against the officers who sit on the files and do nothing. It is presumed that this court will condone delay and even in making submissions, straight away the council appeared to address on merits without referring even to the aspect of limitation, as happened in this case, till we pointed out to the council that he must follow limitation. We are thus constrained to send a signal, and we propose to do in all matters today, where there are such inordinate delays that the government or state authorities coming before us must pay for wastage of judicial time, which has its own value. Such costs can be recovered from the officer's responsible period of delay and the casual manner in which application has been worded. We consider it appropriate to impose costs on the petitioner state of Rs 25,000 to be deposited with the Mediation and Conciliation Project Committee. The amount be deposited in 4 weeks. The amount be recovered. And number 9, the special petition is dismissed as time bar. So, Your Worship, again, in this case, there was a delay of 663 days. Supreme Court has held that file pushing cannot be a grand. We are in a advanced stage where everything can be done through the computer internet. Just sending left done. There, number of correspondents have been shown that they are taking steps, but that cannot be. And another judgment, which is in the same book, page 667. So, Your Worship, this is also a short judgment. I'll just read para 2. Para 2. On 5th of January 2019, it is stated that, page 56. If Your Lordship will see page 56. I'm very sorry, Your Lordship, page 57. Page 57 is the relevant page. Page 57.
Yes.
This is Annexure 5. Para 2 shows that the CGC had given her legal opinion on 22nd of May 23. And if I take Your Lordship to page 85,
(26/3/24).
ultimately it was filed only on 13th of February 2025.
Okay.
This is a very interesting judgment. 1981, 1 SCC 495. Said, it is urged by learned counsel for the appellants that the High Court erred in condoning the delay in filing the appeal, and the appeal would have been dismissed as barred by limitation. We have examined the facts carefully. It appears that initially the state government took a decision not to file an appeal, and it allowed the period of limitation to lapse. Subsequently, on certain observations made by the High Court while considering a revision petition by Bulabai that it was a fit case where the state government should file an appeal, and on notice being issued by the High Court to the state government in the matter, the appeal was filed. It was filed 3 months after limitation period had expired. A faint attempt was made to show that was taken not to file an appeal. All the papers had not been considered by the department concerned. But we are not impressed by the allegation. The truth appears to be that the appeal was not filed at first because the state government saw no case on merits for an appeal, and it was filed only because High Court had observed, and that was long after limitation had expired, that the case was fit for appeal by the state government. Now, it is true that a party is entitled to wait until the last day of limitation for filing an appeal, but when it allows limitation to expire and pleads sufficient cause for not the sufficient, and there is no cause arising within the limitation period to condone the delay. They were sending letters to the Ministry of Law. Ministry of Law opined that there is no prima facie case for appeal. But in spite of that, again they started corresponding with each other. Then in the end, they decided to file an appeal. So within the limitation period, there was no reason, there was no sufficient cause to condone the delay. No decision was taken except corresponding with each other. And my learned friend has relied upon a judgment of the coordinate bench where the delay has been condoned. But, Your Worship, in that case, the reason for condoning the delay was on medical grounds. The applicant was sick for, the husband was bedridden because of stroke, and the applicant was sick due to cancer. So taking those reasons into consideration, the delay was condoned. So I'd like to differentiate here. The facts are totally different here.
So many times. My learned friend also know very well.
But I don't know. You have to convince me. Do you have that copy of notification?
Now, yes, on date, I am not getting that copy. However, I can produce before the court, my lord.
You
If
give it to me.
necessary.
I'll pass the orders in chambers
Yes, my lord.
today itself. Can you
I'll
give
try
that?
to get it today.
Okay. Anything else you
No,
have?
no, my lord.
I'll pass the orders in chambers.
Right.
Item 9.
Counsel for petitioner who today due to some personal difficulty of the conducting counsel Mr. Johnny, conducting counsel for the petitioner Mr. Johnny L. Taucha. Consider the learned additional public prosecutor does not opposes the prayer. Considering the ground, the prayer is allowed. Let this matter be listed again on which day?
Lordship, 2nd of July.
On 2nd of July.
Yes.
10. Your Lordship, I'm appearing on behalf of Mr. Bilaram Ea, counsel for the. As I have inquired, the court has received the TCR, and as no paper book is required, may this matter be put up for hearing in the.
This is a POXO matter, NDPS case.
Yes, Your Lordship.
Yes, Your Lordship, I believe that TCR was already called on 14/5/2025.
Has
As per
it?
the orders. It's already received.
Okay. Paper book has to be prepared.
Yes, Your Lordship.
Heard Miss Sarah,
Lalpan Sangi,
learned counsel appearing for Miss
Mr. Bilaram Ea.
Mr. B. Lalremenga, learned counsel for the applicant. Also heard Miss learned additional secretary. Perusal of the office appears that the trial court records which were requisitioned in this case have been received. Stop. The registry is directed to prepare
Judgment, item 14.
For the reasons mentioned in the judgment, this criminal revision is allowed. The impugn order dated 12/11/2015 passed by the trial court is hereby set aside and the case is remanded back to the trial court with following direction. The trial court shall, after giving opportunity to the prosecution side and the accused persons, shall consider the materials available on the record, including the police report as well as documents sent along with it afresh, and thereafter take a decision as to whether charges are required to be framed under section 240 against any of the accused persons or all of them, or they are liable to be discharged under section 239 of the Code of Criminal Procedure. As the respondents are represented by the engaged counsel before this court, they are directed to appear before the trial court on when?
22nd July, my lord.
30 July. 30 July is okay?
30 July.
30 July. This revision petition is accordingly disposed of.
Highly obliged.